Calais case is such a tortured exercise. It's
Mr.
difficult.
Cox, I don't want to hear.
So I'm going to tell you what
I want you to answer
SFFA,
my
how
question.
SFFA applies to Calais.
Did he get it right or
He did not get it
wrong?
right.
Tell
So
me in simple terms, is that not what the court said?
The court said a lot of things that were inaccurate. So
what happens when the government uses race to decide who gets an advantage and who doesn't? That was the central issue during a tense Senate hearing when Senator John Kennedy pressed a lawyer over racial gerrymandering and whether race can be used when drawing congressional districts. Kennedy wasn't interested in a complicated legal explanation. He wanted a simple answer: can the government use race as a factor, or is race supposed to be off the table? And as the questioning continued, Kennedy became increasingly frustrated with the answers.
Thank you, Mr. Chairman. Mr. Grime, am I saying your name right?
You are, Senator.
You argued the Calais case?
I did.
Okay. I'm going to tell you my understanding of the case. And then, Mr. Cox, I'm going to ask you to tell me if Mr. Grime got it right. And Mr. Chamberlain, you can chime in if you would like. Are you familiar, Mr. Grime, with the Students for Fair Admissions case?
I am.
Okay, that's the case recently where the Supreme Court said you can't use race in college admissions. Now, here's what I heard the Supreme Court say in that case. I heard the Supreme Court say, look, colleges, we're not going to get into the admissions business. That's your business. We're just telling you you can't use race as a factor to admit anybody. Is that your understanding of the case?
Basically, yes. And they did a whole 14th Amendment.
Don't try to muddy the water to make it look deep, guys. I know you're all smart. I'm just trying to get to the bottom line. Am I wrong or right?
You're right.
Okay. Now, the way I read Calais is the Supreme Court is saying, look, first of all, these are political questions. And we're not going to tell the states how to draw congressional districts. We don't want to be in that business. That's a political question. We're just saying you can't use race as a factor. Is that what they did in Calais, or am I misunderstanding it?
That's basically it. You can use it to remedy, past discrimination that you've proven. But that wasn't the case in the Calais case. The other side didn't prove it.
Well, but once again, you're muddying that water, man. Did the court, or did it not, say that you can't use race to draw a congressional district?
In most cases, you can't unless the state, the person defending the map, shows that they had to use it because there was a showing of immediately past intentional discrimination, that they had to use race to unwind.
Okay.
Yeah.
Tell me whether he got it right, Mr. Cox.
Senator, quite frankly, the defense of the Calais case is such a tortured exercise. It's
Mr.
difficult.
Cox, I don't want to hear.
So I'm going to tell you what
I want you to answer
how
my question.
SFFA applies to Calais.
Did he get it right, or
he did not get it
wrong?
right? Okay. So under application to discuss Calais, you have to really discuss what happened in the case that created the district that was challenged in Calais. That was Robinson.
All right.
The court required the state of Louisiana to redraw its plans pursuant to its findings of a Section 2 violation.
Look, I don't
That's
want to have
what
a fight.
justified the creation of the plan.
I don't want to have a fight. Can you just tell me? And you're smart, and I don't want to make this more complicated than it is. Tell me what he got right or wrong.
I'm telling you, what he got wrong was ignoring...
No, you're speaking like a lawyer, okay? And I'm tired of... I've listened to you gentlemen, okay? Let's just get down to it. Mr. Chamberlain, tell me what Mr. Grime got right or wrong.
He got it all right. You think I'm really going to tell the guy who argued and won Calais that he didn't understand what he was arguing?
Okay.
Sorry, no, I'm totally respectful. Yeah, obviously, I think he's got a good handle on it.
I understand that, Mr. Cox. I don't mean to be rude, the importance of precedent and all that. But didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person, and that includes in drawing congressional districts.
In answering that question, I'm going to tell you that the Robinson Court, which gave rise to the district that was challenged in Calais, said that there was a violation of the Voting Rights Act, that it was required to draw a district or draw a redistricting plan that satisfied the Voting Rights Act, that allowed African Americans to elect candidates of choice.
You don't want to answer my question, do
challenged.
you, Mr. Cox?
I'm answering your question.
No, you're not.
It may be an answer that you don't like or my colleagues don't.
No, you're not.
But I'm answering
your
question.
You're giving us another lecture, and this is not a common law class. Tell me in simple terms, is that not what the court said?
The court said a lot of things that were inaccurate. So that court said you can't use race at all in drawing plans. We disagree with that. But what the court really did was say that you can prove race you can prove there's intentional discrimination, which is in violation of this Congress's intent. It also sprinkled partisanship as a defense for any challenge to any challenge under Section 2.
All right, well, I'm about out of time. I can see, no disrespect, Mr. Cox, but you're not answering any of my questions. And I know you're disappointed in the decision. But let me put it another way. Do you think race should be used to help a person?
I don't understand that question. Race should be used to help a person?
Do you think race should be used to help a person?
I believe that if there is a racial violation of the law, that race discrimination, I believe a remedy that's race conscious can be required, yes.
Do you think race should be used to harm a person?
I don't really understand what that question means.
No, I didn't think you would. Mr. Chamberlain, do you think it's fair in America to use race to help a person at the expense of other races?
No.
Do you think it's fair in America to use race to hurt another person?
No.
How about you, Mr. Graham?
Absolutely not. Race should not be used to help or hurt an individual.
And no disrespect to Mr. Cox. He's very bright. I can see that. And I've been where you've been. You know, when you get in front of a court of appeal and you're losing, you want to kind of obfuscate. I get it. But that to me is what the court's saying here in all these cases. We're not going to try to run your business. Not in the college admissions, not in drawn districts. But you can't use race. Period. End of discussion. And I think that's what the Constitution says and what most Americans support. I know you're disappointed, Mr. Cox.
I'm not disappointed. I'm outraged.
But that's what the Constitution says.
Well, can I add one more thing that's
Sure.
not quite exactly addressing what you asked? I do think there's a role for a co-equal branch of government, Congress, to make its own determination regarding how it wants its laws enforced. And I would urge this Congress to reconsider Calais in that light.
Yeah, but you and I are both aware that the United States Supreme Court has full authority to pass on the constitutionality of a statute. Come on, you know that. I'm sorry, Mr. Chairman.
If Mobile versus Bolden is any example of what can and can't happen, this Congress can take a look at Calais and say, actually, you got it wrong. And you actually didn't interpret what we intended in 1982 correctly.
The problem with your argument is, I don't think race should be used to help a person because of his race. And I don't think race should be used to harm a person because of his or her race. And I think that's what most Americans believe. And if you don't believe the opposite, and you clearly do, this is America. You can believe what you want. But the Supreme Court is deciding these cases.
I hear you.
Saying race is off the table.
I hear you. And I believe as a civil rights lawyer that if you find a violation based on race, you need to craft a remedy that addresses that.
Sure.
Senator Whitehouse.
I'm sorry.
What happens when the government uses race to decide who gets an advantage and who doesn't? That was the central issue during a tense Senate hearing when Senator John Kennedy pressed a lawyer over racial gerrymandering and whether race can be used when drawing congressional districts. Kennedy wasn't interested in a complicated legal explanation. He wanted a simple answer. Can the government use race as a factor, or is race supposed to be off the table? And as the questioning continued, Kennedy became increasingly frustrated with the answers. Kennedy started by drawing a comparison to the Supreme Court's decision on race and college admissions. His argument was straightforward that if the Supreme Court has said that race cannot simply be used as a factor in deciding who gets admitted to college, Then what happens when government officials draw congressional districts? Can race be used to benefit one group, or disadvantage another? Kennedy pushed the lawyer for a direct answer. But instead of giving him the simple yes or no response he wanted, the attorney began explaining the circumstances in which race-conscious government action may still be legally permitted. And that's where Kennedy began pushing back. Kennedy repeatedly tried to bring the conversation back to the basic principle that he wasn't asking for a history lesson. He wanted to know whether the Supreme Court had established a rule that race cannot be used to help or hurt an individual simply because of their race. As the attorney continued explaining the legal background, Kennedy interrupted and pressed for clarity. His frustration was obvious. Kennedy's position was essentially this: if the government claims that Americans must be treated equally, then why should race play a role in determining who benefits from a government decision? That question became the centerpiece of the exchange. Then Kennedy simplified the entire debate. He asked whether race should be used to help someone because of their race. The attorney explained that there are limited circumstances where race-conscious remedies can be legally justified, particularly when racial discrimination has been established. Kennedy then flipped the question. What about using race to hurt someone because of their race? The attorneys agreed that racial discrimination should not be used in that way. Kennedy seized on those answers. To make his larger point, his argument was that Americans should not be advantaged or disadvantaged simply because of the racial category into which they were born. And that's when the hearing moved beyond redistricting and into a much broader constitutional debate. Kennedy's argument centered on equal treatment under the law. His position was that government has enormous authority to organize elections and administer public institutions, but that authority doesn't automatically mean officials can use racial classifications however they want. The opposing legal argument was different. The lawyer maintained that Congress can enforce civil rights protections and, in certain circumstances, race-conscious remedies may be necessary when unlawful discrimination has been proven. So the disagreement wasn't simply about whether discrimination is wrong. The real question was when, if ever, can the government legally consider race in an effort to correct discrimination? Kennedy wanted that line drawn as narrowly as possible. By the end of the exchange, Kennedy had repeatedly returned to the same principle. Race should not determine who gets an advantage or who gets punished. The attorney, meanwhile, argued that there are narrow circumstances under existing civil rights law where considering race can be legally justified. That left the hearing with two competing visions of equality. One side says equality means government should treat people without regard to race. The other says that when discrimination has been proven, limited race-conscious remedies may sometimes be necessary to achieve equal treatment. And Kennedy clearly wasn't satisfied with leaving the issue there. John Kennedy's questioning ultimately reduced a complicated legal dispute to a question that is much easier to understand. Should the government ever use race to decide who gets an advantage, or who gets hurt? Kennedy's answer was clear. Race should be taken off the table except where the law narrowly requires otherwise. The attorney's position was that there are circumstances where race-conscious remedies can still be legally necessary. And that's what made this exchange so contentious. If you want more coverage of the biggest moments from Congress and the Senate, subscribe and turn on notifications so you don't miss the next explosive hearing.